Main topics we will cover include what is an information disclosure statement and what is entailed by duty to disclose. We will cover when an IDS should be filed and what should be included in an IDS. We will also cover how an examiner should handle an IDS. Applicants and other individuals substantively involved with the preparation and/or prosecution of the application have a duty to submit information to the office which is material to patentability as defined in 37 CFR 1.56. There are a variety of reasons why they may want the office to consider information. For example, to make sure that the examiner has an opportunity to consider the same information that was considered by these individuals, or by another patent office in a counterpart, or related patent application filed in another country. Next, we will cover a sample IDS form and then discuss in greater detail what is entailed by duty to disclose. A sample information disclosure statement form, PTO/SB/08A, is shown here. The top portion of the form contains application-related information which the examiner should ensure is up to date when reviewing the form. A detailed discussion on how to handle the actual IDS form will be covered towards the end of the presentation. The IDS form itself is basically a list of references where each type of reference is listed separately. There are 3 types of references on the form. 1. U.S. patent documents. 2. Foreign patent documents. And 3. Non-patent literature. The first 2 types, 1. U.S. patent documents, and 2. Foreign patent documents, are shown here. The third and last type, 3. Non-patent literature, or NPL, is shown on the second page here. Note that there is also a place for the examiner to sign and date at the bottom of the form. Applicants and other individuals substantially involved with the preparation and/or prosecution of the application have a duty to disclose to the office all information known to that individual to be material to patentability as defined in 37 CFR 1.56. The next few slides will cover who has a duty to disclose as defined in 37 CFR 1.56. Information disclosure statements, IDSs, are not permitted in provisional applications filed under 35 U.S.C. 111B. Since no substantive examination is given in provisional applications, a disclosure of information is unnecessary. Any such statements filed in a provisional application will be returned or destroyed at the option of the office. Individuals, defined according to Rule 37 CFR 1.56, are 1. Each inventor named in the application. 2. Each attorney or agent who prepares or prosecutes the application. And 3. Every other person who is substantively involved in the preparation or prosecution of the application and who is associated with the inventor, the applicant, an assignee, or anyone to whom there is an obligation to assign the application. 37 CFR 1.56a also states that the duty of candor and good faith is owed in dealing with the office, and that all associated with the filing and prosecution of a patent application have a duty to disclose to the office material information. This duty in dealing with and to the office extends, of course, to all dealings which such individuals have with the office, and is not limited to representations to or dealings with the examiner. For example, the duty would extend to proceedings before the Patent Trial and Appeal Board and the Office of the Commissioner for Patents. This concludes our brief discussion on what is entailed by a duty to disclose. An examiner must check to see if an Information Disclosure Statement, IDS, complies with 1. All the time-related requirements of 37 CFR 1.97, which are based on the time of the filing of the IDS, and 2. All content requirements of 37 CFR 1.98. The procedures for submitting an information disclosure statement under the rules are designed to encourage individuals to submit information to the office promptly and in a uniform manner. Now, we will focus on when should an IDS be filed. The procedures and requirements under 37 CFR 1.97 for submitting an information disclosure statement are linked to 4 stages or periods, as illustrated on the current slide. In the processing of a patent application, Stage 1 occurs before filing of the first action on merits. Stage 2 begins after the first stage and ends prior to closing prosecution of the application. For example, before mailing of final office action or notice of allowance. Stage 3 begins after Stage 2 and ends before or with payment of issue fee. Finally, Stage 4 begins after the issue fee has been paid and up to the time the patent application can be withdrawn from issue. In general, the requirements for filing an IDS are greater as you move across the 4 stages or periods from left to right. These requirements will be discussed in detail next. In greater detail, Stage 1 comprises A. National applications within 3 months of filing, or before the mailing of a first office action on the merits, whichever is later. B. International applications within 3 months of the date of entry of the national stage as set forth in 37 CFR 1.491, or before the mailing of a first office action on the merits in the national stage application, whichever is later. And C. Continued examinations. For example, RCEs filed under 37 CFR 1.114, and CPAs filed under 37 CFR 1.53D, before the mailing of a first office action on the merits. For applications filed during the first stage or period, there is no requirement under 37 CFR 1.97 since the office encourages the filing of an IDS as early as possible during examination. During Stage 2, which is after the mailing of the first action on merits, but before mailing a final action, notice of allowance, or quail action, the applicant has the option of either providing a statement under 37 CFR 1.97E or paying a fee under 37 CFR 1.17P. The concept of the statement will be discussed in detail later during the presentation. During Stage 3, which is after Stage 2 but before or with payment of issue fee, the applicant must provide both the statement under 37 CFR 1.97E and pay the fee under 37 CFR 1.17P. During Stage 4, which is after payment of issue fee, the IDS will typically not be considered. However, the IDS may be considered under the QuickPath IDS, Cupid's pilot program, or if the application is withdrawn from issue at this point so that the information can be considered in the application upon filing of an RCE. As noted previously, the requirements become more strict during prosecution of an application from Stage 1 to Stage 4. A QuickPath IDS, or CUPIDS, is a pilot program to allow applicant submissions of prior art after a notice of allowance has been mailed. The purpose of the QuickPath IDS program is to reduce the need for reopening prosecution via a request for continued examination, RCE, after payment of the issue fee, thereby assisting in achieving office pendency reduction goals, encouraging compact prosecution, and improving stakeholder satisfaction. Examiners may receive additional other time, up to 3 hours, after using the correct time code to consider a CUPIDS request. There are two paths for a CUPIDS. Path 1 for submissions prior to or with payment of the issue fee, and Path 2 thereafter. For Path 1, applicant must file the IDS with a fee and certification, 1.97e. If the prior art is cause for reopening, fill out a PTO 2300 form and get a TC director's signature on it according to your TC process. Once the PTO 2300 is mailed, you may mail your action. For Path 2, applicant must file the IDS with a fee, certification, 1.97e, a e-petition to withdraw from issue, authorization to charge an RCE fee. If the prior art is cause for reopening prosecution, fill out a PTO 2300 form and mail it. The case will have the RCE entered and go on your docket. In either path, if the case remains allowable, then complete a corrected notice of allowability. If you have a printer rush due to this CUPIDS, remember to respond to the printer. Examiners may determine if they have a QuickPath IDS CUPIDS request by checking to see if the issue fee has been paid and that the contents of the file wrapper also contains a cupids.req document, PTO/SB/09. A sample of the PTO/SB/09 document is shown on the slide. Please consult your SPE or trainer for additional information on how to determine if you have a CUPIDS request or how to further handle the request. Examiners must check to see if an Information Disclosure Statement, IDS, complies with 1. All the time-related requirements of 37 CFR 1.97, which are based on the time of the filing of the IDS, and 2. All content requirements of 37 CFR 1.98. We will now discuss the content requirements for filing an IDS under 37 CFR 1.98. The first requirement under 37 CFR 1.98a is that all U.S. patent documents, foreign patent documents, and non-patent literature, NPL, must be listed separately on the IDS form. Note that when we discussed the sample IDS form on slides 5 and 6 at the beginning of the presentation, each of these sections were separate on the IDS form PTO/SB/08A. In addition to the list of information, each information disclosure statement must also include a legible copy of A. each foreign patent, and B. each publication or that portion which caused it to be listed, other than U.S. patents and U.S. patent application publications unless required by the office, and C. for each cited pending unpublished U.S. application, the application specification, including the claims, and any drawings of the application or that portion of the application which caused it to be listed, including any claims directed to that portion, unless the cited pending U.S. application is stored in the Image File Wrapper (IFW) system. There are exceptions to providing a legible copy of a cited reference. 37 CFR 1.98c states that when the disclosures of two or more patents or publications listed in an information disclosure statement are substantively cumulative, a copy of one of the patents or publications may be submitted without copies of the other patents or publications, provided that a statement is made that these other patents or publications are cumulative. 37 CFR 1.98d states that a copy of any patent, publication, pending U.S. application, or other information listed in an information disclosure statement is not required to be provided if a. the information was previously cited by or submitted to the office in a prior application, provided that the prior application is properly identified in the IDS and is relied on for an earlier filing date under 35 U.S.C. 120, and b. the IDS submitted in the earlier application complies with 37 CFR 1.98 A through C. If both of these conditions are met, the examiner will consider the information previously cited or submitted to the office and considered by the office in a prior application relied on under 35 U.S.C. 120. This exception to the requirement for copies of information does not apply to information which was cited in an international application under the Patent Cooperation Treaty. If the information cited or submitted in the prior application was not in English, a concise explanation of the relevance of the information to the new application is not required unless the relevance of the information differs from its relevance as explained in the prior application. The requirement for a copy of each U.S. patent or U.S. patent application publication listed in an IDS has been eliminated unless required by the office. Each information disclosure statement must further include a concise explanation of the relevance, as it is presently understood by the individual designated in 37 CFR 1.56c, most knowledgeable about the content of the information listed that is not in the English language. The concise explanation may be either separate from the specification or part of the specification. If the concise explanation is part of the specification, the IDS listing should include the page or line numbers where the concise explanation is located in the specification. If a complete translation of the information into English is submitted with the non-English language information, no concise explanation is required. An English language equivalent application may be submitted to fulfill this requirement if it is, in fact, a translation of a foreign language application being listed in an information disclosure statement. There is no requirement for the translation to be verified. Submission of an English language abstract of a reference may fulfill the requirement for a concise explanation. Where the information listed is not in the English language, but was cited in a search report or other action by a foreign patent office in a counterpart foreign application, the requirement for a concise explanation of relevance can be satisfied by submitting an English language version of the search report or action which indicates the degree of relevance found by the foreign office. This may be an explanation of which portion of the reference is particularly relevant, to which claims it applies, or merely an X, Y, or A indication on a search report. Now, we will switch gears and talk about a different topic. the 37 CFR 1.97E statement. Recall in Stage 2, under 37 CFR 1.97 mentioned earlier, applicant has the option of either providing a 1.97E statement or paying a fee under 37 CFR 1.17. We will now discuss what is meant by providing a statement under 37 CFR 1.97. The statement comes in one of two forms, depending on the situation. The first form is as follows. 1. That each item of information contained in the information disclosure statement was first cited in any communication from a foreign patent office in a counterpart for an application not more than 3 months prior to the filing of the statement. This allows applicant to file an IDS without having to pay a fee if they timely provide the information cited on a foreign search report within 3 months prior to the filing of the statement. The second form of the 1.97E statement is as follows. 2. That no item of information contained in the information disclosure statement was cited in a communication from a foreign patent office in a counterpart foreign application, and to the knowledge of the person signing the statement after making reasonable inquiry, no item of information contained in the information disclosure statement was known to any individual designated in 37 CFR 1.56C more than 3 months prior to the filing of the statement. Either form of the 1.97E statement is typically found in the cover letter accompanying the IDS form PTO/SB/08A or 08B. Information disclosure statement will be reviewed for compliance with the requirements of 37 CFR 1.97 and 37 CFR 1.98. Applicant will be notified of compliance and non-compliance. If the IDS does not comply with 37 CFR 1.97 and 1.98, it will be placed in the file, but none of the information will be considered by the examiner. A forum paragraph, 6.49 to 6.49.10, should be used to address any reference that was not considered. Applicant may then file a new IDS or correct the deficiency, but the date that the new statement or correction is filed will be the date of the statement for purposes of determining compliance under 37 CFR 1.97. An examiner should line through items not considered on Form PTO/SB/08A or 08B. If all items are not considered, then the examiner can write "not considered" with a diagonal line drawn across the form. If an item is not considered, then the examiner should explain why the item was not considered in their office action using one of the provided Oaks form paragraphs. If an IDS complies with the time of filing requirements, but part of the content requirements is inadvertently omitted, the examiner may set a 1-month time limit to correct the omission. Use form paragraph 6.51. The examiner will consider the documents cited in the International Search Report in a PCT National Stage application when the form PCT/DO/EO/903 indicates that both the International Search Report and the copies of the documents are present in the National Stage file. In such a case, the examiner should consider the documents from the International Search Report and indicate by a statement in the first office action that the information has been considered. There is no requirement that the examiner lists the documents on a PTO 892 form, and reference cited on the search report will not be listed on any patent if not provided on a separate list of an IDS form. Use form paragraph 6.53 to 6.55. The initials of the examiner placed adjacent to the citations on the PTO SB/08A and 08B or its equivalent mean that the information has been considered. In addition, the following alternative electronic signature method may be used by examiners in information disclosure statements to indicate whether the information has been considered. As an alternative, examiners will no longer initial each reference citation considered, but will continue to strike through each citation not considered. Each page of reference citations will be stamped by the examiner with the phrase, "All references considered except where lined through," along with the examiner's electronic initials, and the final page of reference citations will include the examiner's electronic signature. Examiners must consider all citations submitted in conformance with the rules, and their initials when placed adjacent to the considered citations on the list or in the boxes provided on a form PTO/SB/08A and 08B, or the examiner may use the alternative electronic signature method noted on the previous slide, provides a clear record of which citations have been considered by the office. The examiner must also fill in his or her name and the date the information was considered in blocks at the bottom of the PTO/SB/08A and 08B form. If any of the citations are considered, a copy of the submitted list, form PTO/SB/08A and 08B as reviewed by the examiner, will be returned to the applicant with the next communication. Those citations not considered by the examiner will have a line drawn through the citation, and any citations considered will have the examiner's initials adjacent thereto, or the bottom of each page of the information disclosure statement may include the phrase, "All references considered except where lined through," along with the examiner's electronic initials. The original copy of the list, form PTO/SB/08A and 08B, will be entered into the application file. The copy returned to applicant will serve both as acknowledgement of receipt of the information disclosure statement and as an indication as to which references were considered by the examiner. Forms PTO 326 and PTOL 37 include a box to indicate the attachment of form PTO/SB/08A and 08B. Occasionally, documents are submitted and relied on by an applicant when replying to an office action. These documents may be relied on by an applicant, for example, to show that an element recited in the claim is operative or that a term used in the claim has a recognized meaning in the art. Documents may be in any form, but are typically in the form of an affidavit, declaration, patent, or printed publication. To the extent that a document is submitted as evidence directed to an issue of patentability raised in an office action, and the evidence is timely presented, applicant need not satisfy the requirements of 37 CFR 1.97 and 37 CFR 1.98 in order to have the examiner consider the information contained in the document relied on by applicant. In other words, compliance with the information disclosure rules is not a threshold requirement to have information considered when submitted by applicant to support an argument being made in a reply to an office action. However, consideration by the examiner of the document submitted as evidence directed to an issue of patentability raised in the office action is limited to the portion of the document relied upon as rebuttal evidence. The entirety of the document may not necessarily be considered by the examiner. For example, if applicant submits and relies on 3 patents as evidence in reply to the first office action, and also lists those patents on PTO/SB/08A and 08B, along with 2 journal articles, but does not file a statement under 37 CFR 1.97E or the fee set forth in 37 CFR 1.17P, it would be appropriate for the examiner to indicate that the teachings relied on by the applicant in the 3 patents have been considered, but to line through the citation of all 5 documents on the PTO/SB/08A and 08B, and to inform applicant that the information disclosure statement did not comply with 37 CFR 1.97C. Now, we will switch gears briefly for a special situation that may occur during examination. We will discuss a special case on when it may be appropriate to go final in a subsequent action during Stage 2 or Period 2 under 37 CFR 1.97, after a first office action, but before the mailing of a final action, notice of allowance, or quail action. However, before we discuss this special situation, let's briefly discuss when it would not be appropriate to make the next office action final. If information submitted with a 37 CFR 1.97E statement during the period 2 after a first office action, but before the mailing of a final action, notice of allowance, or quail action, is used in a new ground of rejection on unamended claims, the next office action should not be made final. The next office action will not be made final since in this situation it is clear that the applicant has submitted the information to the office promptly after it has become known and the information is being submitted prior to the final determination on patentability by the office. Likewise, if information submitted with the 37 CFR 1.97E statement during the period 2 after mailing of the first office action, but before mailing of a final action, notice of allowance, or quail action, is used in a new ground of rejection on amended claims, the next office action will be made final if the new ground of rejection was necessitated by amendment by applicant. In other words, the rejection may be made final as necessitated by the amendment. Now, let's discuss the special situation that may occur. If information submitted with a 37 CFR 1.17P fee only during the period 2 under 37 CFR 1.97E after a first office action but before mailing of a final action, notice of allowance, or quail action, is used in a new ground of rejection, the next office action will be made final whether or not the claims have been amended, provided that no other new ground of rejection, which was not necessitated by amendment, is introduced by the examiner. This situation may not occur that frequently, but it is something that you should be aware of during examination. You should now know what is an Information Disclosure Statement, or IDS. You should know what is entailed by a duty to disclose under 37 CFR 1.56. Examiners must check to see if an Information Disclosure Statement, IDS, complies with 1. All the time-related requirements of 37 CFR 1.97, which are based on the time of the filing of the IDS, such as the 4 stages or phases discussed, and 2. All content requirements of 37 CFR 1.98. Finally, you should now know how an examiner should handle an IDS. You should now know what is an Information Disclosure Statement, or IDS. You should know what is entailed by a duty to disclose under 37 CFR 1.56. Examiners must check to see if an Information Disclosure Statement, IDS, complies with 1. All the time-related requirements of 37 CFR 1.97, which are based on the time of the filing of the IDS, such as the 4 stages or phases discussed, and 2. All content requirements of 37 CFR 1.98. Finally, you should now know how an examiner should handle an IDS.